Dear students, hearty good afternoon to all of you. Dear students, we were discussing how partition is effective. And in the last class, we have discussed the siblings of status or interest and expression of intention. And we have seen that how expression of intention is very crucial and very important. Before we start the second concept of communication of intention, I would like to revise a few basic points. But we all know that the partition is an eventually very important or eventual in joint into family, through which the joint status of a family comes to an end. And partition also give rise to new joint families or nuclear families. Partition it must be at least there should be some two co-partners as said by various tourists. In the Hindu joint family, because then only there would be a state of jointness among the co-partners, which will come to an end by the partition. So further, it implies that unless a co-partnery exists in a family, the concept of partition is not what we can say cannot take place. The concept of partition, which we have seen, is applied with different rules. Okay, and each school is having its own rule. When we try to check the Dayabhaga school, the Dayabhaga school, when we talk about the term partition, which means division of property in accordance with the specific shares. Okay, we have discussed this thing, and Mitakshara school is talking about division of property into specific shares. Okay, not merely means any sort of, we can say, division of property into specific shares, but it basically means severance of joint status. And essentially, co-partner is important, but existence of joint family is not essential for demanding partition. So it is a law by which the joint family status terminates and the co-partnership comes to an end, and all that is necessary to constitute is a partition is a definite, unequivocal declaration of the intention by a co-partner to separate himself from the family, which we have discussed in all these cases. The effect of partition is that the partition leads to separation. And whenever we talk about that partition leads to separation, which means that after partition, each individual is free from the rights and duties which used to exist earlier and the responsibilities. The share of the co-partners get defined and stop fluctuating further due to the births and deaths in the family, which further they used to have. So property acquired by co-partner after partition is treated as self-acquired or separate property, which devolves by succession. So essential of partition, we can say essence of partition, which we can say that partition must not be confused with the de facto division of property and allotment of the shares. When we say de facto, we have discussed, but I'm trying to give you a brush. I'm trying to brush with you because so that you should not have any confusion. So partition by meets and bound is not mandatory ingredient for completing the process of partition. Physical division of property affects the mode of enjoyment and management only and not the nature of its tenure. Okay, so strictly speaking, partition is said to be a completed the moment the severance of joint status takes place, which I am trying to discuss with you again and again. If you are able to see on your screen, I'm moving my mouse, severance of status. So when we say a partition is said to be completed the moment the severance of joint status takes place, and it happens with the expression of intention. The co-partnery is a creature of Hindu law. The concept of co-partnery encompasses community interest and unity of possession. Each co-partnery rights exist to the whole of family. Each one of them has an interest in the whole family, and he and persons are having a, we can say that each co-partner's rights extend to the whole joint family, and also no definite shares are there. So partition takes place by two modes or two ways. The very first is the de jure partition, when the community of interest is broken or divided and converted into a fixed share, leaving no scope for application of doctrine of survivorship. This type of partition is known as de jure partition. In other words, the severance of the joint status again and again by different what I can say dimensions. I am trying to relate this particular concept to in your mind that how it happens. And the second is de facto partition. So unity of possession can be maintained here after severance of joint status. The shares might get fixed but no co-partner can claim any property as falling into this exclusive share. It is not clear that the property will go to which co-partner. This is the unity of possession. And when it is broken by actual physical division of the property and replaced by the exclusive possession, it is called de facto partition or partition by metes and bonds. So here we are discussing de jure partition with the expression of intention. This is what I was trying to uh, correlate, although we have studied in the last lecture, but so that the things are fresh in your mind. So this we have seen. Now coming to the communication of intention, as I told you, I will be dealing it in a separate lecture, because we know that the intention to see or maybe can be expressed in any mode. So it is necessary that the intention to see receiver must be communicated to the other co-partners, and uncommunicated expression of the intention at best can amount to a desire to a partition. Okay, so it can amount to severance. The most important or the essential is the unequivocal communication of intention must be a conscious and informed act of a co-partner. Co-partner are responsible for the communication of unequivocal communication. The difficult question in this connection, we can say, or we can, after going through the text or studying the cases, are that when should the communication of intention to receiver be deemed effective? From the date on which the communication is put into transmission, or from the date which it reaches to the co-partner. So, ancient texts are not able to throw much light, but in the case of Suraj Narayan versus Iqbal Narayan, it was held that it is essential that the intention must be communicated to the other co-partner. And in the case of Babu Ramshre versus Radhika, the Privy Council said that severance may be effected by giving a clear and unmistakable intention by his acts or declaration of a firm intention to become separate. So a clearly and unmistakable intention of the acts, they should be declared. Okay. It was discussed in the case of Babu Ramshre versus Radhika. So a series of decisions have taken place. These series of decisions which are there, also it was held that in the case of Kama versus Meenakshi, in the Madras High Court, lays down that the sequence of status is effected from the date of communication is put into transmission. The moment it has been communicated and had been transmitted, for example, we can say that the moment a letter, notice, or a telegram was dispatched. Now we are living in a different, we can say, world, but this case is very old one, 1931, and I hope that you people are able to understand, because you people have already gone through the law of contract, in which dear students, you people have seen what usually happens. We are appreciating classical law, and the classical law is trying to reflect its what was the practice during that particular point of time. So here also the same thing appears, or same thing applies. Okay, which was discussed in the case of Kama versus Meenakshi. In another case, which is there, Raghava versus Chechanamma, this case, the Supreme Court has discussed regarding the question for consideration, and reviewing Justice Subba Rao is a very famous judge, has given some sort of observations and also the conclusions which were made in the case of Raghavamma versus Chechanamma, which is somewhere related. Which we can call it. We can say that this somewhere related with the view of communication, and we can call it the uh, the communication of intention. Okay, so what happened? The communication of intention was discussed in this case. To see what must be communicated to the all interested parties. Whenever there is a communication of intention of to see what to end the relation, it should be communicated to all the parties, interested parties, and interested parties means that the co-partner alone and not the members of joint family. The co-partners are the people who are there, and not every member of the family. Also, it was discussed in this case that the communication of intention is to be made to all interested parties which might be received by them on different dates. Their receipts will relate back to the date of notice. Okay, so severance will be effective from the date of which the communication was put into transmission. But this is a subject to the proposition what is coming and what is, because every fact of the case is different. And also, it was held in this case that the vested rights, when we talk about the term vested rights, that might accrue in the interval between and the date of transmission and receipts are preserved. And also, it was explained that between the two dates, the person expressing his intention may lose his interest in the family property. Okay, he may withdraw his intention to divide, he may die before the intention to divide is conveyed, or what we can say that other members. A manager of a joint family may sell away the entire family property for the debts binding upon him or on the family. There may be similar, we can say, other instances also if the doctrine of relating back is invoked without any limitation thereon, vested rights so created will be effected and certain titles may be distributed. So these are the higher findings of the case which I am trying to bring in, although it is not so much what you can say that related with your concept which we are discussing, but as I told you that the role of the teacher is not only to cover the syllabus but to uncover it. So don't get confused. Just stick to that the communication of the intention to receiver must be communicated to all other, we can say, interested parties. And interested parties means co-partner and not all the members of joint family. I hope it is clear to you. So the complication are there on account of the proposition which have been discussed in this case, and mode of service has to be looked in, its efficiency has to be looked in, service of notice on manager, but rather it will be enough, whether the service of notice on major members or substantial body of them will suffice, and how the notice has to be served on minor members. So these are the, we can say, questions which haven't been answered in this particular case law, but as time has evolved, there were many ample number of cases, and one of the cases was Putranganna versus MS Rangamma, in which these questions were discussed. The process of communication, which may vary, which we can say the circumstances of each particular case, the proof of formal dispatch or receipt of the communication by other members of the family is not essential, nor it is absence fatal to the severance of the status. So the court held that the communication was sufficient and effective and it could not be withdrawn. So there are many number of cases in which the things have been discussed and the things have been appreciated. So dear students, we have seen that a notice is given to the co-pastor and who refuses to accept the communication, it is deemed to be enough. It is something which suffices the cause and it is effective. Also, the notice to the karta, we can say, is the notice to the minor, which has also been appreciated in other cases, and it has been established that once the intention is declared and is communicated, and the communication has been made, the severance of status take place. Assent or dissent of other co-pastors is immaterial, whether they are accepting it or rejecting it. Are you able to get it? That is what important, which we have seen. Okay, that how partition is effected under the severance of status or interest. Now we have to start the second topic of your syllabus, modes of partition. So mode of partition, when we talk about the term mode of partition, we have to understand this particular term in the light of the few case laws which are there. Okay, there are few case laws which are, we can say, by which we are able to analyze the thing. We have to understand that partition can be made by a definite, unambiguous declaration of intention. Okay, please excuse me, I want to have some water. A partition can be made by a definite, we all know, unambiguous, and a declaration of what we can call intention of any co-partner to separate himself from the family. And if this is done, it will amount to a division of status. whatever mode may be used. So partition may be effected by institution of a suit or by submitting the dispute as to division of the properties to arbitration, by demand for a share in the properties. Okay, so by conduct which are there an intention to sever the joint family property. It may also be affected by an agreement to divide the property. So in the case of Sri Kalippa versus Muthu Sunu Muthu Sunu Min, in this particular case, it was held that it was discussed that the deepening a well, laying underground pipes, getting loan or security of a portion in one's possession are not adequate proof of what we can say partition. So partition should have adequate proof if one is trying to lay some pipes and getting loan or security of portions of one's possession. If particular individual or co-partner is asking for a loan on whatever he's having, it is not an adequate proof of what we can call it of partition. So further, we can divide partition into few modes which are there. First is the partition by suit, then partition of joint family, partition by agreement. Okay, so when we talk about the term partition by suit, so partition by suit is that when a co-partner files a suit for partition, it amounts to an unequivocal intention or intimation of the intention, which we have discussed, or rather we were discussing from last few lectures. And that intention to sever and consequently severance of status take place from the date the suit is instituted. A degree may be necessary for working out of the results of severance for division of property by metes and bounds. But severance has taken place from the date of the filing of the suit and not from the date of the degree. Okay, so decisions taking the view that a partition is effected by a degree of a court are wrong. So in a suit of partition, the initial burden is on the plaintiff to show that the entire property is a joint family property, which we have already discussed if you are able to recall some lectures in which we have seen this particular concept. So dear students, in the case of Kedarnath versus Ratan Singh, it was held that the Privy Council said that if the suit is withdrawn before the trial, if the trial is going on, before that the suit has been withdrawn, the plaintiff not desiring separation, there is no severance of status. If suppose the suit has been brought, but the suit was the what we can call the plaintiff was not in a mood to carry on the suit, to continue it, and he withdraws it. So it doesn't amount to an partition. Okay, there is no, we can say, severance of status, and this decision has to be interpreted, which means that before the summons are served on the defendants. Okay, so you will be going through what is meant by the summons and all those things under Civil Procedure Code, how the parties have been called in the court of law. Right now, you have to understand it means a sort of an invitation which is given to ask them to come to the court of law. Okay, so in another case, the case of Radhakrishnan versus Satya Narayan case, it was held that when all the defendants in the partition suit were served with the summons and issued was settled, one of the defendant dies. So whereupon the plaintiff sought to withdraw the suit, the Madras High Court has said that the division of the status had already been brought about by plaintiff, and therefore it was not open to him to revoke the intention. If a particular person has died, his intention will be carried. The same thing which we see in the wills, if you are able to recall it, in the last module we will be discussing with it. Also in the family law, we would be discussing the concept of the wills, in which the last will is very crucial. Here also, the court has taken the similar, what we can call the line of arguments by saying that the status had already been brought about by the plaintiff, and therefore it was not open to him to revoke the intention because the intention has been already made. Okay. Now we have to see the another case. The name of the case is the Puttarangana versus Raganna, and in this particular case, the decision was approved by the Supreme Court and the submission of the situations of the parties were free to recruit, and also that a suit for partition must include all joint family properties and all persons interested in the joint family properties, so such as the co-partners and other people who are having the right of maintaining, whether they are the females or the other parties, they have to be considered also. So these are the things which we have seen. Also, we can say that the parties are free to partition some of the partitions, to make some of the partitions, which we call partial partitions. So similarly, it is not necessary that the suit for partition must be between all co-partners. It may be between the branches. In that case, only parties necessary to partition suits are head of the branches. So these are the things which have been discussed in the case of partition by suit. Okay, students. Now further we have to see the concept of partition of a joint family property. So in this particular case, there is one case which I would like to discuss with you. That is the Haliram Sharma versus Buladatt Sharma. But before we go to this particular case, we have to understand that what is meant by the term partition of joint family. There are brothers who constitute the joint family property. The canteen, the businesses are there. And in this particular case, what happened? There were three brothers who constituted the joint family, and they used to have some canteens and restaurants which was run by one of the brothers. The joint family business and that of, we can call it the that of earning of business suit property, was purchased in the name of a defendant brother. And the statement of the plaintiff brother that he had also paid certain amount of money to the defendant to purchase of the said property was not found reliable. There was also no material to show that the defendant has ever thrown that particular property into a joint stock with the intention of abandoning his separate claim in a self-acquired property. Okay, so what happened? There was no material to show that the defendant has ever thrown the property into a joint stock with the intention of abandoning his separate claim in the self-acquired property. The suit would be not belong to a joint family property, but plaintiff will not be entitled to claim any share in it and the property which is partitioned. The amount of compensation or any sale proceeds which are obtained by the defendant will exclusively belong to him, and the plaintiff will not be entitled to claim of accounts from the defendant. And the reason we know that the brothers failed to prove that it was a joint family business, okay, which is something which we can say a separate property or separate business. So why to ask for it? So partition of a joint family could be made or will be done only with the joint family and nothing with the separate property. Okay, now we have to see what I would like to say, that we have to discuss this concept of partition by agreement. And the very first case is that a partition may be effected between the parties by an agreement itself. Okay, in the case of Approvia versus Rama, in this particular case, the intention being the real test, it was held that the intention being the real test and agreement between the co-partners to hold and enjoy property in defined shares as a separate owners operate as a partition. Okay, although actual division of property might not have taken place. So in such case, what happened? The interest of the each co-partner is served, though the property remains physically undivided. It is something one, but what happened? The co-partner's interest is ended. Also, when we see the particular case of what we can say in the Puru and Chi versus Gopal Swami case, in this case also what happened? An agreement to constitute partition must define the shares of co-partners. An agreement to constitute partition must define the shares of co-partners. It was held with an intention to an immediate separation. Otherwise, such an agreement will not be lead to a severance of status. So in this particular case, it was held that an agreement to constitute partition must define the shares, what shares they are trying to bring in. Okay, and furthermore, we can say that in the case of Rama versus Pura, in this case, it was held that a deed embodying such intention is conclusive. Whenever there is a deed which is telling about the intention, that acts as a evidence, as a conclusive evidence itself. So, unregistered partition deed can be used for a collateral purpose also to show the intention of partition. So, these are the different, we can say, elements of the partition by agreement. A partition also may get affected of an agreement between the co-partners of a tenanted house and whose division, we can say, of rent has not been made is valid, and an injunction can be issued also at the instance of a co-partners that others could not interfere with the portion of the property which is coming or falling under the share. So there are different what we can call it instances in which a partition can be made by agreement. Under the Hindu law, an agreement to a partition need not be in writing. If it is in writing, it should clearly indicate the intention to partition. Okay, the parties are not free also to alter what we can call or modify the legal effects. Okay, the parties are not free to alter or modify the legal effects of an agreement by subsequent act or conduct. If the intention was something, they are not in a position. In no case they can modify or alter the legal effect. What has been we have seen what is the legal effect. We have discussed in detail. So they are not free. The parties are not free. So there are certain limitations also when we talk about partition by agreement. The severance of status takes place from the date of signing the agreement. The moment the agreement has been signed, it happens. The relationship is ended. A written agreement not be registered, we can say, if it merely records what had happened. So the properties are divided by the agreement and registration is also necessary. Okay, these are the essential crucial elements of what we can call it partition by agreement itself. So there are other modes also. We can say that if you are trying to discuss, for example, oral partition is there. So there is no long line of cases holding that view that the oral partition can be validly made. So since partition is not an convenience of property, the transfer of property does not apply, and there is no other law requiring a partition to be evidenced by writing. So early in 1846, what we have seen the Privy Council in some of the cases said that it is undisputed that a division of a joint property might be effected without an instrument. Okay, in writing. Since then, the courts have consistently taken the view and held the view that it is that for a division of a joint family, an instrument is there, it should be there. The rationale behind the principle is that the partition does not involve transfer of property. Okay, in its nature of mutual renunciation of rights. It's so that it can be made orally. So when we talk about that, it can be made orally. This was discussed in the case of Sareen versus Ajit in the year 1966, sorry, and in the case of Girja versus Sadashiva in the case in the year 1916. So the Privy Council has laid the foundation and has held that it is undisputed that a division of a joint family property might be effected without an instrument in writing. Okay, and the reason which has been provided is that the partition does not involve the transfer of property. So in this nature of we can say mutual renunciation of rights is there, and therefore an oral what we can call partition can be made. So dear students, this is for today. As we are having a meeting of academic planning committee, and in the morning also I was there in the meeting as a part of the committee. The meeting lasted 2 hours, and there are some work which have been allotted to us, and therefore I have to complete that work. Again, we have to meet. Upon that, I have to report 2 lectures. So instead of wasting today's, so what I thought and what I planned, uh, I have allocated 30 minutes to both the we can say the classes and for both the recordings of the lecture. So hopefully we will meet tomorrow, and there I will like to throw more light, and we can start the second topic of our syllabus. So as I'm engaged today, instead of just skipping this thing, or because I haven't done it in the past also, every day I'm trying to record the lectures for you, and this is the reason, because of my pre-engagements with some other works, academic exercises are there. We have to see the syllabus part also. So again, we have to meet and I have to complete some work. So I'm ending here today, and hopefully we will continue in the next class. Thank you for your patient listening. Thank you.